Mr. President, members of the Court, it is a great honor for me to address the Court on behalf of the Republic of Colombia in these proceedings. Our presence here today bears witness to Colombia's tradition of respect for international law, but it also reflects Colombia's deep concern about the incidents that regularly occur between the State of Palestine and the State of Israel, exacerbated after the horrific events taking place since 7th October 2023, which have unleashed a cycle of violence that has only worsened an already calamitous situation, causing the death of more than 27,000 civilians and thousands of wounded. Colombia rejects any recourse to violence or unilateral acts that lead to a higher level of confrontation. We also believe that holding states accountable for violating international law, especially when their actions bring about dire humanitarian consequences, is a sign of respect for the rule of law. Colombia has expressed before and reiterates today that the occupation of the Palestinian territory is a violation of international law and is contrary to the principles enshrined in the Charter of the United Nations. Furthermore, as the Court itself stated in the construction of a wall opinion, it is clear that both Israel and Palestine have the obligation to abide by international law and to respect and ensure respect for international humanitarian law and human rights law within the occupied Palestinian territory. Both states also need to implement in good faith all relevant Security Council and General Assembly resolutions. Additionally, Colombia fully shares the Court's view in its advisory opinion on the construction of a wall to the effect that the United Nations and the General Assembly in particular need to redouble efforts to encourage a negotiated solution to the outstanding problems on the basis of international law and with the purpose of the establishment of a fully viable Palestinian state existing side by side with Israel and its neighbors, fostering peace and security in the region. Nearly 2 decades after that landmark decision was issued, and in light of the gravity of the current situation in the occupied Palestinian territory, the advisory opinion to be rendered by the Court in these proceedings shall provide much-needed guidance to the UN system and third states in order to continue supporting both states, reaching a solution through dialogue and based on mutual respect. Colombia thus considers that through its advisory opinion, the Court can contribute to clarifying the law, especially the rules governing the consequences of violations to peremptory norms of international law, namely rules of jus cogens and erga omnes obligations, and to specific legal regimes which are the concern of all of mankind. Mr. President, I will begin by referring to the issue of the jurisdiction of the Court to render the requested advisory opinion. By virtue of Article 65, Paragraph 1 of the Statute of the Court, 2 requirements must be met for the Court to have jurisdiction to give an opinion. 1, there must be a formal request from a body duly authorized by the UN Charter or in accordance to it to make such a request. And 2, the question put before the Court must be a legal question. It is undisputed that the General Assembly is one of the bodies authorized to make such a request in line with Article 96, Paragraph 1 of the Charter, and that the decision of the General Assembly to submit the questions contained in Resolution 77/247 was adopted in accordance with its rules of procedure and by the required majority. A significant number of states, member states, including Colombia, decided it was important for the General Assembly to receive guidance on the questions put to the Court. Therefore, the request observes the first requirement. The second requirement, namely that the question put before the Court be a legal one, is also complied with in the present case. Indeed, in your jurisprudence, particularly, for example, in the Nuclear Weapons Advisory Opinion, you've clarified that a question is a legal one when, and I quote, the Court is asked to rule on the compatibility of the request with the relevant principles and rules of international law, end of quote. In other words, questions framed in terms of law and raising problems of international law, whereby the court is asked to identify and apply principles and rules of international law, qualify as questions of a legal character. Colombia considers that the questions raised in Resolution 77/247 are indeed framed in legal terms, since they request the court to determine the legal consequences arising from the policies and practices of the State of Israel, a member state of the United Nations in the occupied Palestinian territory, including East Jerusalem, and to ascertain how those actions affect the legal status of the occupation. Those questions are to be answered through the application of rules of international law and therefore constitute legal questions which could form the basis of a request for an advisory opinion. Thus, in the opinion of Colombia, the court has jurisdiction to respond to the questions contained in Resolution 77/247. Mr. President, I will now focus on the question of propriety. In this respect, while Article 65, Paragraph 1 of the Statute of the Court gives the court discretionary power to give or not an advisory opinion that has been requested from it, in its case law, the court clarified certain important points, namely, first, that the court may give an advisory opinion should be interpreted to mean that the court has always a discretionary power to decline to give an advisory opinion even if the conditions of jurisdiction are met. And second, the court is always mindful of the fact that its answer to a request for an advisory opinion represents its participation in the activities of the organization and, in principle, should not be refused. While certain states have expressed opposition to the request by the General Assembly, the reasons argued are, for the most part, quite similar to those dismissed by the court in its advisory opinion on the construction of a wall. In that case, the court decided to render the requested opinion as, in its own words, and I quote, "Differences of views on legal issues have existed in practically every advisory proceeding," end of quote. Colombia posits that the court's thorough reasoning then, soundly grounded on its long-standing jurisprudence, is directly applicable to the current request. Consequently, Colombia considers that the court should reach the same conclusion in the present proceedings. That is, that it can and will exercise jurisdiction, and that there are no compelling reasons for it to use its discretionary power not to render an opinion. Hence, Colombia invites the court to pronounce the law on the legal consequences arising out of serious breaches of peremptory norms of general international law and thus assist the General Assembly in the proper exercise of its functions, the United Nations in discharging its responsibilities in this matter, originating, as the court recalled, in the mandate and the partition resolution concerning Palestine, and all states who possess an interest in the protection of erga omnes obligations. Mr. President, an additional important circumstance that should be factored in by the court when deciding as to the propriety of rendering its advisory opinion is that the situation in the Palestinian occupied territory has changed drastically since the request was transmitted to the court in January 2023. On 7th October of the same year, Israel was the victim of a horrifying attack by Hamas. We all know the scale and the magnitude of Israel's reaction to the attack. The court itself has already been confronted with the veritable map of horror and devastation which the Gaza Strip has become as a result of the total war and scorched earth policies unleashed by the government of Israel. Indeed, in several passages of its order of 26 January concerning provisional measures in the case brought by South Africa against Israel on 29 December 2023, the court took judicial notice of some details of this dire situation. To quote just one of such passages in the court's own words, the court considers that the civilian population in the Gaza Strip remains extremely vulnerable. It recalls that the military operation conducted by Israel after 7 October 2023 has resulted, inter alia, in tens of thousands of deaths and injuries, and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war will take many more long months. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. End of quote. Evidently, the factual matrix of that case and the background of these advisory proceedings are not identical. And in particular, the request by the General Assembly has a wider scope than South Africa's application in at least two respects. One, in that the requested advisory opinion refers to the policies and practices of Israel in the whole Palestinian occupied territory and not only in the Gaza Strip. And two, in that it covers all actions that Israel carries out in such territory and not only the actions and omissions by state agents that, according to the applicant in the contentious case, amount to genocide. But the point remains that those policies and practices, which in Colombia's view contravene essential norms of international law, have taken a turn for the worse as a result of Israel's military campaign unfolding in Gaza. Today, a place of death and despair that, in the words of an impartial source, has simply become uninhabitable. Colombia respectfully submits that the court should not underestimate the fact that the situation in Gaza has become more deadly over the past months, and therefore, the legal consequences of such actions must be even more serious today than in the world we were living before this bloodshed started. Against that distressing background, and for all the reasons explained above, the government of Colombia, in line with its policy of pursuing total peace both within and beyond its borders, calls upon the court to avail itself of the opportunity to clarify legal aspects that may pave the way for the parties to resume a fruitful discussion and achieve peace, and support the General Assembly to better assist them in that purpose. Mr. President, let me address now the questions submitted to the court by the General Assembly. The questions relate to the legal consequences arising from Israel's ongoing violation of the right of self-determination of the Palestinian people as a result of its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, and for all states and the United Nations from this ongoing occupation. In order for the court to rule on those questions, it must first determine, 1, whether Israel is violating the right of self-determination of the Palestinian people, and 2, whether Israel's prolonged occupation, settlement, and annexation of the Palestinian territory since 1967 is in violation of international law. An answer in the affirmative to both questions will then enable the court to address the ensuing legal consequences. With regard to the first issue, as mentioned, in the Wall advisory opinion, the court stated that Israel is bound to comply with its obligation to respect the right of the Palestinian people to self-determination, and in doing so, it is obliged to respect international humanitarian law and international human rights law. The General Assembly routinely reaffirms such right by means of an annual resolution on the matter. Regarding the second point, Israel's prolonged occupation and further annexation of the Palestinian territory is in manifest violation of the rule of international customary law, which clearly prohibits the acquisition of territory by force. It also blatantly ignores the UN Charter and the findings of this court in its advisory opinion on the Wall case. An occupation that includes the annexation de facto of the occupied territory amounts, in Colombia's view, to an illegal acquisition of territory by use or threat of force and to a denial of the right of self-determination. Furthermore, the occupation violates peremptory norms of general international law. In addition, as the court recalled in its 2004 advisory opinion, Israel's policies and practices involving the establishment of settlements in the occupied Palestinian territory are contrary to the terms of Article 49, Paragraph 6 of the Fourth Geneva Convention, to which Israel is a party. Given that the Israeli occupation has, since its onset, been acquisitive in nature, and consequently, its policies and practices in furtherance of that occupation have resulted in imposed persecution, racial discrimination, and apartheid over the Palestinian people, it can only be found to be in breach of various international legal obligations incumbent upon Israel. Mr. President, with regard to the consequences of those violations, Colombia is of the view that Israel's actions contrary to international law engage its responsibility and therefore entail distinct legal consequences. First of all, Israel is obliged to cease its violations and to return to a situation of compliance with the obligations it has breached. Consequently, Israel is bound to put an end to the prolonged occupation, settlement, and annexation of the Palestinian territory. It must do so unconditionally, immediately, and completely. It must cease the continuing internationally wrongful acts and should offer appropriate assurances and guarantees of non-repetition. Israel also must respect international humanitarian law and international human rights law vis-à-vis the Palestinian people. Moreover, Israel must make reparations for the damage caused. The court's jurisprudence on the essential forms of reparation and customary law is clear. Israel likewise has an obligation to compensate, in accordance with the applicable rules of international law, all natural or legal persons having suffered any form of material or immaterial damage as a result of its occupation upon the Palestinian territory. Israel also has violated erga omnes obligations, and as the court indicated in the Barcelona traction case, such obligations are, by their very nature, the concern of all states, and I quote, "In view of the importance of the rights involved, all states can be held to have a legal interest in their protection." End of quote. Given the character and the importance of the rights and obligations involved, it follows that all states are under an obligation not to recognize the illegal situation resulting from the occupation of the Palestinian territory. They are also under an obligation not to render aid or assistance in maintaining the situation created by such occupation. As the court has asserted, and I quote, "It is also for all states, while respecting the UN Charter and international law, to see to it that any impediment to the exercise by the Palestinian people of its right to self-determination is brought to an end." End of quote. Finally, Colombia believes that states must cooperate within the multilateral framework of the United Nations. In the present situation, the organization, and especially the General Assembly and the Security Council, should consider what further and urgent action is required to bring to an end the illegal situation resulting, in the instant request, from Israel's illegal occupation. The Court's guidance is crucial for that purpose. Mr. President, to conclude, Colombia respectfully calls upon the International Court of Justice to give the advisory opinion requested by the General Assembly. Ultimately, what is at stake here is ensuring the safety and, indeed, the very existence of the Palestinian people, bearing in mind the real and imminent risk of irreparable prejudice to the rights of Palestinians as a consequence of Israel's occupation, as has been fully documented by international agencies, United Nations organs, and even recently recognized by the Court itself. As the Court stated 2 decades ago, and one of its members recently recalled, and I quote, "The United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy." End of quote. And so does the Court, as the principal organ, judicial organ, of those United Nations. Thank you, Mr. President, members of the Court. This concludes my presentation on behalf of the Republic of Colombia.
I thank the delegation of Colombia for its presentation. I invite the next participating delegation, Cuba, to address the Court. I call upon Her Excellency Ana Yancy Rodriguez Camello to take the floor.
Good morning, Mr. President, distinguished members of the Court. It is an honor for me to address you on behalf of the Republic of Cuba. On July 2023, the Republic of Cuba presented its written submissions as part of the advisory opinion on the legal implications resulting from Israel's practices and policies in the occupied Palestinian territories. Our delegation appears before this solemn sitting as an expression of Cuba's genuine interest in and commitment to peace, and based on its historical and unconditional solidarity with the peoples that are subject to colonialism and foreign domination. The Palestinian people, its girls, boys, women, and civilian population as a whole, continue to be massacred due to the illegal use of force by Israel, the occupying power. All this takes place with the complicity of countries such as the United States of America, responsible under international law for genocide, war crimes, crimes against humanity, and the apartheid regime that determines where people can live, work, and move around depending on their ethnic and religious backgrounds. Members of the Court, we and you bear the high moral, historical, and legal responsibility to pronounce ourselves in a clear, transparent, and forceful manner on the ignominious situation of the Palestinian people and to demand international responsibility for what is happening in the occupied territories. The current context highlights the importance of the question circulated by the UN General Assembly Resolution 77/247. The presentation of the Cuban delegation has been structured as follows. In the first part, we will discuss the essential legal elements that should serve as the basis for establishing the international responsibility of the occupying power and all other international actors involved. In the second part, we will focus on the legal implications and consequences that should be demanded for such internationally wrongful acts or omissions. Finally, on behalf of the Republic of Cuba, I will present our conclusion on these proceedings. Referring to the first part, the violation of the ban on the threat or use of force, equal rights, and free determination of peoples have been amply documented before the international community and this very court. Israel's occupation of Palestinian territories is an international wrongful act, the reiteration and duration of which aggravate the responsibility of the occupying power before the Palestinian people and the international community. The prohibition to acquire territories by threat or the use of force is a rule of customary international law with broad regulatory and jurisdictional recognition. This prohibition applies regardless of whether the territory is acquired as a result of an act of aggression or self-defense. The UN Charter, which is the basic international legal instrument for the new international order and the contemporary international law, is very clear in this regard. This treaty, of which the Statute of the International Court of Justice is an integral part, establishes in Article 2.4 that every state shall refrain from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purpose of the United Nations. The Charter itself, in Article 1.2, recognizes as one of its purposes respect for the principle of equal rights and self-determination of peoples, which are systematically and flagrantly denied to the Palestinian people. These violations of general customary international law stand erga omnes. In relation to the specific question before the International Court of Justice, it should be pointed out that since the adoption of Resolution 242/1967 of the Security Council, it was agreed that Israel's armed force would withdraw from all the territories occupied during the 1967 conflict and that the 1949 Green Line would be recognized as the demarcation of the borders between Israel and Palestine. The occupation of the Palestinian territories is also considered as a wrongful act of annexation in accordance with the provisions contained in Resolution 476 and 478 of 1980 and 497 of 1981 of the Security Council, which state that the acts of Israel oriented to the annexation of East Jerusalem and the Golan Heights are null and void and should not be recognized by states. These spurious attempts have also included maneuvers to change the international status of the Holy See of Jerusalem. Some states not only recognize and accord legal status to Israel's policies and practices, but act with complicity and blatant impunity to prevent the international community, including the United Nations, from stopping the ongoing genocide. Under the declaration of the granting of independence to colonial countries and peoples, adopted by UN General Assembly Resolution 1514, the Palestinian people have the inalienable right to determine their own political, economic, and social destiny. This is in keeping with the recognition of equal rights and self-determination of peoples, peremptory norms endorsed in the UN Charter, the Human Rights Covenants, and the Declaration on Principles of International Law concerning friendly relations and cooperation among states, in conformity with the Charter agreed upon by UNGA Resolution 2625. The presence of Israeli settlements in the occupied territories, the forced changes to the demography of the Palestinian people through land occupation and forced displacement of people, the construction of the separation wall, the control exercised over their natural resources, and the restrictions imposed on their mobility undermine and deny the ability of Palestinians to exercise their right to self-determination. Israel is also in violation of Resolution 242/1967 of the Security Council and the Oslo Accords. These agreements state that no party shall commence or take any step that would modify the status of the West Bank and the Gaza Strip pending to the outcome of negotiations on the permanent status. The destruction and appropriation of property in occupied territories, which are not justified by military necessity and are carried out on a large scale, unlawfully and arbitrarily, constitute grave breaches of the Fourth Geneva Convention relative to the protection of civilian persons in time of war, and therefore constitute a war crime. The Palestinian question demands a clear statement on the legal implications resulting from the non-applicability and violations of the Fourth Geneva Convention. Land, sea, and air blockades constitute collective punishment and are extreme violations of freedom of movement and the enjoyment of economic, social, and cultural rights. Collective punishment is expressly prohibited by international humanitarian law and is incompatible with several international human rights law provisions. The written submission presented by Cuba to this court provides well-documented evidence, particularly the serious violations of the Convention on the Prevention and Punishment of the Crime of Genocide. The genocide against the Palestinian people is not limited to the current stage of the extermination war by Israel. All this with the complicity of the United States of America, which prevents the international community from acting to protect the Palestinian people. The justification for fighting terrorism and exercising the right to self-defense are deceitful when they are raised by the aggressors themselves. The legal consequence of current and past events should not be analyzed in a fragmented manner. Taken as a whole, this institutionalized violence, which makes no distinction between civilians and combatants, is part of a broader policy that also includes, in a systematic and organized manner, massive confiscations of land and property, unlawful killings, extrajudicial executions, torture, administrative detentions, forced transfers, restriction on movement, and the denial of nationality and citizenship to the Palestinian population. There is also a discriminatory economic and cultural policy aimed at impoverishing the Palestinian population and denying the realization of their fundamental human rights. The International Court of Justice should make a general assessment of this situation so as to determine the legal implications resulting from it. In this regard, the Republic of Cuba believes that rather than an obvious apartheid regime situation prosecuted as a crime against humanity, this is indeed an act of low-intensity genocide that is perpetrated with systematic and effective cruelty. To qualify Israel's action merely as acts of apartheid would leave out the implicit intention to exterminate the Palestinian people, either in part or as an ethnic and religious group to whom the right to self-determination is denied. In case there was any doubt about the arguments that Cuba presented to the court in its brief, the current situation that is taking place in the eyes of all confirms the ongoing genocide. Innocent victims, girls, boys, women, civilians in general, numbers in the thousands. For the Genocide Convention to apply, the life of one single victim or the incitement, attempt, or conspiracy to commit such acts would be enough. The Convention Against Genocide also punishes the accomplices and instigators, those who veto decisions and prevent the international community and the United Nations from taking action, those who oppose an immediate ceasefire and the delivery of humanitarian aid, those who, for years, have supported each and every one of the policies and practices of Israel, the occupying power, which deny the existence of the Palestinian people and their rights. This agenda, to a large extent, has advanced in the course of time. We are convinced that this court should not wait for the complete extermination of an entire nation before ruling on the matter. That was the intention of the UN General Assembly in requesting the advisory opinion. The terrible situation currently facing the Palestinian people is a reminder of the urgency of a clear and consistent statement on the questions submitted to the consideration of the court. Israel, the occupying power, and its allies must take responsibility for the legal implications resulting from the sustained non-compliance with the international law. Consequently, the analysis of the international responsibility of Israel should go hand in hand with the responsibility of the United Nations and the member states that hinder its actions, creating by sustained and continued omission an international wrongful act that aggravates and worsens a clear situation of violation of international law in the Palestinian occupied territories. There should be a clear and unanimous ruling by the court that impartially and independently establishes the legal implications resulting from depriving the Palestinian peoples from their fundamental rights, including the right to life, freedom, and self-determination. Mr. President, members of the courts, related to the second part, added to the aforementioned international violations, there is the indolent attitudes of Israel, the occupying power, of ignoring the numerous resolutions and decisions adopted by the UN General Assembly, the Security Council, and the International Court of Justice. In this regard, and without intending to cover all issues, Our brief to the court contains a report on the violations of the aforementioned provisions. In line with the foregoing and all other relevant opinions that may be contributed by other states, the main legal implication from this violation, resulting from this violation of international law, should be the declaration of the international legal responsibility of Israel, the occupying power, and its accomplices. All this based on the series of conventional and customary primary rules of international law that have been violated by Israel. Likewise, the aforesaid responsibilities and legal consequences must be established for Israel and its accomplices, in accordance with the secondary rules of state responsibility for internationally wrongful acts contained in the draft articles of the International Law Commission, as reflected in document A5610. It would be appropriate for the court to provide in its advisory opinion that the international responsibility of Israel covers all illicit acts or omission of its state bodies, and those executed by persons or entities exercising powers of public authority, acting in the absence of official authorities or under the guidance or control of the occupying power. These secondary rules that govern the international responsibility of states clearly establishes the guidelines to determine the legal implication of the internationally wrongful act. This would motivate a strong ruling by the court, indicating the immediate obligation of all states, in particularly the occupying power, to comply with the conventional and customary norms flagrantly and systematically violated in the Palestinian territory, including the cessation and non-repetition and reparation for the damage caused to the Palestinian people referred to respectively in Articles 29, 30, and 31 of the draft Articles on Responsibility of States. All of the foregoing is without prejudice to the applicable provisions of treaty law. In addition, the International Court of Justice should separately address the international responsibility of other states for the aid and assistance they offer to Israel, including those that supply weapons. It is an undisputed fact that certain members of the organization violate the principles reflected in Article 2 of the Charter, not only by denying the sovereign equality and rights of the State of Palestine, but also by acting in bad faith in such a way that precludes any possibility for a negotiated solution to the conflict that, far from being resolved, has worsened over the last 70 years. In all these years, the United States has systematically and consistently overused its veto power to prevent any effective action by the Security Council and to ensure impunity to Israel. Just yesterday, the U.S. vetoed for the 48th time a Security Council resolution related to the Palestinian question. The International Court of Justice should emphasize the scope of Article 2.5 of the UN Charter, which states that all members shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. This entails the obligation of all states to abide by the decisions adopted by the organization as a whole, particularly when the Security Council remains passive by the indolent attitude of one of its permanent members, the United States of America. And the United Nations General Assembly has continuously and categorically taken a stand on this question, supported by the International Court of Justice. Mr. President, members of the courts, to conclude, and based on the foregoing and especially taking into account the unbearable situation of the Palestinian people, the Honorable International Court of Justice should take a stand in the clearest, strongest, and most forceful legal terms in support of international law. The advisory opinion should establish the legal implications for Israel, other states, and the United Nations for the violation of the norms against the threat or use of force, equal rights and self-determination of people, as well as of the main international human rights instruments, the Geneva Convention on the Protection of Civilian Persons in Time of War, the Convention on the Prevention and Punishment of the Crime of Genocide, and the continued non-compliance with decisions of the UN General Assembly, Security Council, and the International Court of Justice. A special pronouncement would be merited by the issues related to the character and status of the Holy See of Jerusalem, Holy City of Jerusalem, in light of the continuous violation by Israel and the regrettable inaction of the United Nations, a direct result of the abusive and irresponsible exercise of the veto privilege in the Security Council. The Court should carefully think about the legal implications of these actions or omissions. We understand that once the Court has declared the existence of a situation of violation of international law, for example, the commission of a crime of genocide, war crime, or crime against humanity, there should be clear legal implications for all states that act in a way that ignores or undermines the decision or opinion of the Court. Actions or omissions that support violations of general international law should be held to be incompatible with the exercise of any international privilege. Honorable magistrates, it is up to the International Court of Justice to render the peace and justice that the Palestinian people deserve, without political double standards. That is the reason why the delegation of the Republic of Cuba respectfully requests the prompt issuance of an advisory opinion against the many years of genocidal impunity, clearly stating the international implications and responsibilities of those who, on one way or the other, contribute to the extermination of the Palestinian people. The international community requires a pronouncement that makes it clear to those responsible that today they may use their force against the innocent civilians, but this force will not be enough to spare them from justice. I thank you very much.
I thank the delegation of Cuba for its presentation. I invite the next participating delegation, Egypt, to address the court and call Ms. Jasmine Musa to the podium.
Mr. President, distinguished members of the Court, it is my great honour and privilege to appear on behalf of Egypt, of the Arab Republic of Egypt, in this advisory opinion of historical importance, in which the General Assembly is once again seeking the Court's guidance in respect of Palestine. This comes against the backdrop of a 75-year history of displacement, dispossession, collective punishment, and daily, indiscriminate and systematic violence and human suffering of untold proportions. Mr. President, as we speak, Israel's brutal onslaught continues to rage in occupied Gaza, where 29,000 innocent civilians have been killed and almost 2.3 million people forcibly transferred and displaced in violation of international law. Israel is deliberately and wantonly creating conditions of life that are intended to make life in Gaza impossible, imposing siege and starvation, including by impeding humanitarian access and the distribution of relief through constant obstruction and bombardment. With the impending attack on Rafah, where 1.4 million people have sought refuge, Israel is continuing its policy of mass forcible expulsion of Palestinian civilians, all while the Security Council repeatedly fails to call for a ceasefire in callous disregard for Palestinian life. Simultaneously, Israel is continuing its illegal practices in the West Bank, scaling up attacks, access restrictions, punitive house demolitions, and supporting settler violence that has displaced entire communities. Increased settlement activity continues to erode the basis for a two-state solution, dimming prospects for a lasting peace in the region. These ongoing, grave violations of international law by Israel, the occupying power, are part of a wider policy that seeks to dispossess the Palestinians of their land and assert Israeli sovereignty over it. This is manifestly illegal and renders the occupation as a whole unlawful. It is shocking that at this critical moment, some states would rather see this court abscond its responsibility as the principal judicial organ of the United Nations by declining to render this advisory opinion. What message does this send about these states' respect for international justice and the rule of law? Mr. President, I will focus my statement on four main points. Namely, number one, the court's jurisdiction and competence, the legal framework for assessing Israel's prolonged and illegal occupation, which violates non-derogable principles of international law, the purported justifications of self-defense or military necessity, and finally, I will conclude on the legal consequences and a summary of Egypt's submissions. First, on the matter of jurisdiction and competence, the small number of states objecting to the court's exercise of jurisdiction have variously argued that the request is politically motivated, instrumentalizes the court, circumvents the consent of Israel, covers too vast a scope, or will prejudice the peace process and negotiations between the parties. Let me recall that the court has repeatedly and consistently rejected such arguments. In the Kosovo advisory opinion, the court did not concern itself with the motives which may have inspired the request, or the political implications of its opinion. Since the General Assembly is duly authorized under Article 96(1) of the UN Charter and brought forth its request through a validly adopted resolution, the request, in the court's own words, in principle, should not be refused. In the nuclear weapons and Chagos advisory opinions, the court refused to second-guess the decision of the General Assembly, stating that it has the right to decide for itself on the usefulness of an opinion in light of its own needs. Distinguished members of the court, the General Assembly has turned to this august court with what is manifestly a legal question, seeking a legal answer that would indisputably assist in discharging its functions. Allow me to recall that this very court, in the Wall opinion, affirmed the UN's permanent responsibility for the question of Palestine until such time as it may be resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In the Wall opinion, the court found no merit in the proposition, echoed by some in these proceedings, that the ongoing negotiations constituted a compelling reason to decline its competence. It reached a similar conclusion in the nuclear weapons advisory opinion after noting that its opinion would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element on the matter. Indeed, rather than prejudicing the peace process, The present advisory opinion serves not just as an additional element, but rather an essential one for the General Assembly to continue to carry out its role in relation to the Palestinian-Israeli conflict. This is absolutely critical, given the complete absence of any real prospect for a peaceful solution. The Court could not possibly turn its back on this wealth of jurisprudence or disregard the many compelling reasons for it to honour the General Assembly's request. As summarised so aptly by the representative of Palestine, the Middle East region yearns for peace and stability and a just, comprehensive and lasting resolution to the Palestinian-Israeli conflict, based on the principles of international law and the establishment of a viable Palestinian state on the pre-1967 lines, with East Jerusalem as its capital. The legal determination by the Court in the present advisory opinion is indispensable to guide the General Assembly and the international community to achieve this objective. Second, Mr. President, I turn to the question of the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967. Distinguished members of the Court, Palestine has been subjected to the longest protracted state of occupation in modern history, as well as de facto and de jure annexation that confirm the unlawful nature of the occupation. Israel's persistent policy of implanting settlements in the West Bank and occupied Jerusalem for the purpose of creating facts on the ground and breaking up the territorial contiguity of the occupied territories is a blatant disregard for international law. 20 years ago, the representatives of the State of Palestine laid before this Court the facts of Israel's intensive settlement and colonization policy, which had, at the time, transferred 400,000 illegal settlers to the occupied Palestinian territories. Today, that number stands at 750,000, deliberately and permanently altering the status of the occupied territories. In addition to the policy of de facto annexation, Israel purported to annex East Jerusalem de jure through the basic law adopted by the Israeli Knesset in 1980, stipulating Jerusalem, complete and united, is the capital of Israel. The very limited number of states defending these policies advance two principal claims, namely that the legal status of occupation does not change if the occupation is prolonged or involves illegal violations of jus in bello, and that under jus ad bellum, Israeli occupation is lawful since, inter alia, relevant UN Security Council resolutions did not declare otherwise. Egypt submits that the proposition that occupation is merely a de facto situation whose legality cannot be called into question is seriously flawed. As highlighted by a number of participants, the legality of an occupation must be assessed by reference to the UN Charter and general international law. In fact, Israel's prolonged occupation violates a number of distinct legal regimes that exist and operate simultaneously and concurrently. These include, number one, the law of occupation, part of the jus in bello that was characterized by this Court as intransgressible. Number two, the jus ad bellum and the peremptory prohibition of the acquisition of territory through force. Number three, the principle of self-determination, also a peremptory norm of international law, described by this Court as erga omnes and irreproachable in the East Timor case. And four, the fundamental prohibition of racial discrimination, segregation and subjugation. It is against this legal framework that the legality of Israel's policies and practices in the occupied Palestinian territories must be assessed. First, with respect to the jus in bello, it is a fundamental principle of international law that an occupying power is prohibited from changing the status of the occupied territory, as well as its annexation in whole or in part. It is only entitled to exercise limited powers intended to be temporary in nature, with the aim of balancing between its own military needs and the protection of the local inhabitants. These are not rights bestowed on the occupying power, but rather limitations on its authority. It flows from this that belligerent occupation is governed by two key principles. First, it is a temporary regime, and second, it cannot transfer sovereignty to the occupying power. Rather, it freezes the legal order of the occupied territory throughout the duration of the occupation. The occupying authority is merely a de facto administrator, a principle intended to protect both the inhabitants of the occupied territory as well as the separate existence of the state, its institutions, and its laws. This is reflected in Article 47 of the Fourth Geneva Convention, and is precisely what distinguishes occupation from annexation. The prohibition of permanently changing the occupied territory extends also to its demographic component. Article 49 of the Fourth Convention prohibits individual or mass forcible transfer of civilians outside the occupied territory and the transfer by the occupying power of parts of its own civilian population into the territory it occupies. According to the 1958 commentary, this was intended to prevent a practice adopted during the Second World War by certain powers, which transferred portions of their own populations into occupied territory for political and racial reasons and in order, as they claimed, to colonize those territories. As demonstrated in Palestine's statement, there is overwhelming evidence that Israeli support for and maintenance of settlements is intended to permanently alter the demographic composition of the occupied Palestinian territory and extend Israeli sovereignty over it. This is coupled with Israel's mass forcible transfer and forced displacement of the Palestinians in Gaza through its illegal evacuation orders and indiscriminate use of force, which has been labeled by the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territory as ethnic cleansing. It should be highlighted that Article 49 not only prohibits forced transfers, but also, in the court's own words, and I quote, any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population into the occupied territory. Numerous resolutions of the General Assembly and Security Council affirmed the illegality of Israel's settlements, annexation, and measures altering the demographic composition, character, and status of the Holy City of Jerusalem, considering them invalid and a flagrant violation of the Fourth Convention, while requiring Israel to desist from such practices. Security Council Resolution 298 stated, and I quote, all legislative and administrative actions taken by Israel to change the status of the City of Jerusalem, including expropriation of land and properties, transfer of population, and legislation aimed at the incorporation of the occupied section, are totally invalid and cannot change that status. The Council also declared in relation to Jerusalem in Resolution 478 of 1980 that Israeli legislative and administrative measures are null and void and must be rescinded forthwith. Israel remains in defiance of these and subsequent resolutions, including Resolution 2334 of 2016 and numerous General Assembly resolutions, in addition to the provisions of the Geneva Conventions previously described. Israel's prolonged military rule and its strategic settlement policy, considered a national value under Israeli legislation, is essentially a systemic de-Palestinianization of the occupied territory, including Jerusalem, intended to permanently change its demographic characteristics and enhance its Jewish component. thereby achieving the de jure and de facto annexation of that territory. This leads to the conclusion that Israeli occupation is, in fact, an illegal annexation, conquest, and de facto colonial endeavour. Mr. President, the second legal principle by which the legality of Israel's occupation is to be assessed is Article 2.4 of the UN Charter, which prohibits the acquisition of territory through force, one of the most fundamental principles of the post-UN Charter era. The vast majority of states participating in these proceedings submit that Israeli occupation, by virtue of its permanence, de jure and de facto annexation, manifestly violates the principle of inadmissibility of acquiring territory through force. Only one state has attempted to justify Israel's actions by contesting the Palestinians' title to the occupied territories and justifying Israel's territorial expansion as the product of a defensive war. Egypt submits that these claims have no basis in fact or in law, and seek to derail the court by raising issues outside the temporal scope of this request. They are reminiscent of the archaic international law of the 19th century that justified territorial conquest through denying the sovereign status of colonized peoples, relegating them to the realm of terra nullius. There is also no support for the proposition that Israel was acting defensively in 1967. International law recognizes neither preemptive nor preventive self-defense, and the terms of the UN Charter on this matter are clear, requiring an armed attack to occur in order to trigger the right of self-defense. Israel's attack in 1967 was therefore not a defensive but an aggressive war. Even if the claim of self-defense were valid, which clearly is not the case, a decades-long occupation is not reconcilable with the customary international law conditions of necessity, immediacy, and proportionality. In any event, the issue is a moot one, as it is universally recognized that a state may not gain title to territory through any use of force, regardless of its purported legitimacy. These claims also find no basis in Security Council Resolution 242, which unequivocally recognized the inadmissibility of acquiring territory through force, demanding Israel's withdrawal from territories occupied in the recent conflict, and emphasizing the duty of all states to act in accordance with Article 2.4 of the Charter. Resolution 242 was reaffirmed by Resolution 338, while the inadmissibility of territorial acquisition through force was confirmed in at least 9 subsequent Security Council resolutions. In fact, Resolution 471 clearly stated, as far back as 1980, the overriding necessity to end the prolonged occupation of the Arab territories occupied by Israel since 1967, including Jerusalem. In Egypt's view, it is clear that under international law, the territorial status of the West Bank, including Jerusalem and the Gaza Strip, cannot lawfully be altered through armed conflict. Israel's protracted occupation, which is coupled with measures to permanently change the demographic characteristics of the occupied territory and annex part of the land de facto and de jure in violation of the cardinal principle of the prohibition of the acquisition of territory through force, is therefore illegal per se and an ongoing violation of international law. Distinguished members of the Court, the third legal principle against which Israel's conduct must be assessed is self-determination. Egypt submits that Israel's indefinite occupation amounts to a nullification and denial of the Palestinian people's inalienable right to self-determination. It is indisputable that this right, enshrined in Article 1.2 of the UN Charter and both human rights covenants, is a cardinal principle in modern international law. It is Its erga omnes character, confirmed by the court in the East Timor case, entails that all states and international organizations have a legal interest and a duty in respecting and protecting this right. This court already affirmed in the Wall Advisory Opinion the applicability of this right to the Palestinian people. Mr. President, Israel's indefinite occupation of the Palestinian territories is, as a whole, inconsistent with the principle of self-determination and breaches three salient aspects of this principle. First, it obstructs the Palestinian people from freely determining their political status, achieving independent statehood, sovereignty, and the right of return. Second, it deprives Palestinians of their right to pursue their economic, social, and cultural development. In gross breach of international law, Israel restricts Palestinians' access to Jerusalem's Christian and Muslim holy sites, notably Al-Aqsa Mosque, wantonly depletes Palestinian natural resources, imposes access restrictions to Area C, and obstructs the movement of goods and people between the West Bank and Gaza, stunting Palestine's economy and impeding the geographical unity of the State of Palestine. Third, the fragmentation and dismemberment of the occupied territories through Israel's settlements policy, the wall, and measures of de facto and de jure annexation are a blatant violation of the fundamental principle of the integrity of the self-determination unit. The territorial unit of Palestine includes both the West Bank, including the holy city of Jerusalem, and the Gaza Strip. Although Israel withdrew its forces from Gaza in 2005, it still retains effective control by, inter alia, exercising complete control over Gaza's airspace and territorial waters, the flow of people and goods in and out of Gaza, the Palestinian population registry, the tax policy, and transfer of tax revenues. Israel's continuing military incursions into Gaza, including the ongoing brutal assault, indicate Israel's continuing authority over the territory. Together, the West Bank and Gaza constitute a single territorial unit. This has been confirmed by numerous Security Council resolutions which refer to Gaza as an integral part of the territory occupied in 1967 and of the Palestinian state under the two-state solution. Egypt firmly denounces the ongoing obstruction of the Palestinian people's inalienable, permanent, and unqualified right to self-determination, a violation as argued by Palestine that is an essential feature of Israel's prolonged occupation. One only needs to look at Israel's vicious, wholesale destruction of Gaza today, after years of imposing the medieval methods of siege and blockade, to realize the extent of Israel's transgression of this principle. Israel's prolonged occupation is therefore illegal per se, and is an ongoing internationally wrongful act that must be immediately brought to an end by Israel by immediately ending the occupation. The fourth legal principle against which Israel's conduct must be assessed is the fundamental prohibition of racial discrimination, segregation, and subjugation. On a daily basis under occupation, Palestinians face institutionalized discrimination and segregation under a dual legal system applying different laws to Palestinians and Israelis. Israeli military orders in the occupied territories entrench racial discrimination between Palestinians and Israeli settlers. Israel also implements de facto and de jure measures of racial discrimination, including in the areas of detention, criminal justice, housing, land confiscations, and house demolitions. How can such practices, which have been described by a number of participants as crimes against humanity, how can they be consistent with any notion of human rights and human dignity in the 21st century? Israel is under an obligation to repeal all such legislation that maintains its systematic, oppressive, and institutionalized policy of racial discrimination and segregation against the Palestinian people, and to cease all discriminatory policies and practices. I now turn to whether self-defense or military necessity may justify Israel's prolonged occupation. The argument that a state may exercise self-defense against a territory under its own military occupation and effective control is counterintuitive, particularly since the occupying state has the authority and even the obligation to ensure public order and safety in the occupied territory. In the Wall advisory opinion, this court found that Article 51 of the Charter, which recognises the inherent right of self-defence, had no relevance, as the acts invoked by Israel were acts arising out of the occupied Palestinian territory, which is under Israeli effective control and not imputable to another state. Egypt finds no reason for the court to depart from this considered opinion in the current proceedings. The court also rejected the justification of military necessity. The modern conception of military necessity is strictly limited to the contexts in which it is expressly recognized. It is thus already considered in the formulation of the obligations set out in humanitarian conventions, some of which expressly exclude reliance on military necessity. For example, no military necessity qualification is permitted under Article 49, paragraph 6 of the Fourth Geneva Convention, which prohibits the transfer of any part of the occupying power's civilian population into an occupied territory. This cannot be justified as a safety measure taken by Israel in the exercise of its prerogatives as an occupying power. According to the legal maxim, ex injuria jus non oritur, one should not be able to profit from one's own wrongdoing. Israel thus cannot invoke self-defense to maintain a situation created by its own illegal conduct or to justify violations of peremptory norms of international law. Distinguished members of the court, for how much longer do the Palestinian people need to wait before they are able to exercise their legitimate rights under international law? For how much longer will the United Nations continue to manage the humanitarian impacts of Israeli violations without addressing their root cause? History will judge us for how we respond today. Egypt respectfully submits that the court should advise the General Assembly that, number one, the prolonged Israeli occupation is, per se, a continuing violation of international law for its breach of, number one, the jus in bello, number two, the prohibition of the acquisition of territory through force, number three, the right to self-determination of the Palestinian people, and number four, the prohibition of racial discrimination, segregation, and subjugation. Second, Israel, as the wrongdoing state, is obliged to make full reparation through restitution, compensation, and satisfaction, either singly or in combination, by ceasing immediately and unconditionally its unlawful occupation of Palestinian territory and rescinding the associated unlawful policies and practices of annexation, settlements, and discriminatory legislation. Three, all states have a duty not to recognize the illegal situation created by Israel's ongoing violation, resulting from its prolonged occupation, settlement, and annexation of the occupied territory, and not to render aid or assistance in maintaining that situation. Mr. President, the consequences of Israel's prolonged occupation are clear, and there can be no peace, no security, no stability, no prosperity in the Middle East without upholding justice and the rule of law for the Palestinian people. I thank you.
I thank the delegation of Egypt for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.